Hello friends, in the last video we completed the dying declaration part. From this video I will start from section 34 of the Evidence Act. I am reading the section first. Entries in books of account when relevant. Entries in the books of account, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire, but such statement shall not alone be sufficient evidence to charge any person with liability. Illustration: SUs B for rupees 1000 and shows entries in his account books showing B to be indebted to him to this account. The entries are relevant but not sufficient without other evidence to prove the debt. So let me explain the illustration first. SUs B files a case against B for rupees 1000 and shows entry in A's book that B took rupees 1000 from him as a loan. This entry, which is maintained in his books of account in his regular course of business, are relevant but not sufficient without any other evidence to prove the debt. Now I am coming back to the section again. Entries in the books of accounts, including those maintained in an electronic form, regularly kept in the course of business. Note this thing: regularly kept in the course of business are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not alone be sufficient evidence to charge any person with any liability. I thought an interesting case reference will help you to understand this section better. Observation by Punjab and Haryana High Court. It is on your screen. The Bahi means book, which at the most can be said to be a ledger, cannot be accepted to be a book of accounts as contemplated by section 34 of the Indian Evidence Act 1872, particularly when it has neither been so pleaded. It was not pleaded that this is the books of accounts regularly maintained in the course of business, nor proved by the plaintiff appellant that it was being regularly kept in the course of business. The plaintiff appellant did not prove this fact that this particular book is being maintained regularly in the course of his business. In these circumstances, the irresistible conclusion is that plaintiff failed to sufficiently plead and prove its case. So after section 34, I am coming to section 35. Relevancy of entry in public record made in performance of duty. Entry in public record made in performance of duty. An entry in any public or other official record, register or record or an electronic record stating a fact in issue or relevant fact and made by a public servant in the discharge of his official duty. Entry made by a public servant in discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country in which such book, register or record or an electronic record is kept is itself a relevant fact. So any record maintained in the public, any entry maintained in the public record made in performance of duty, any public servant can enter a particular entry in a record which is being maintained by him. He is duly authorized to maintain that record, that book, in discharge of his duty. So that record must be made in discharge of his duty. If he, without any authority, made any entry in the book, that entry will not be covered under section 35. So number one, it must be a public record, it must be recorded by a public servant, and it must be done in discharge of his duty. Another example, another case law in this regard will be very helpful for you. Supreme Court in Jabbar Singh versus Dinesh in the year 2010, very recent. The entry of date of birth of respondent number 1 in the admission form, entry done in the admission form, the school records and the transfer certificates did not satisfy the conditions laid down in section 35 of the Evidence Act, inasmuch as the entry was not in any public or official register. It is not any school record, is not any public register, and was not made either by a public servant. The school was a private school, so the entry was made by a staff of that private school. The maker of the entry is not a public servant, was not made either by a public servant in discharge of his official duty or by any person in performance of a duty specially enjoined by the law of the country, and therefore the entry was not relevant under section 35 of the Evidence Act for the purpose of determining the age of the respondent. So the person used to study in a private school, the record maintained in the public school, the transfer certificate where the date of birth is mentioned, are not relevant, are not covered under section 35, because number one, it is a private school. The entry made by the staff of that private school, not a public servant, so it is not covered under section 35 of the Evidence Act. Now I am coming to section 36 of the Evidence Act. Relevancy of statements in maps, charts and plans. Statements of facts in issue or relevant facts made in published maps or charts generally offered for public sale, or in maps or plans made under the authority of the central government or any state government, as to matters usually represented or stated in such maps, chart or plans, are themselves relevant facts. So maps, chart or plans which are offered for public sale or has been made under the authority of central government or state government are themselves relevant facts under section 36 of the Evidence Act. Section 37. Relevancy of statement as to the fact of public nature contained in certain acts or notifications. Statements mentioned in certain acts or notifications, whether they are relevant. When the court has to form an opinion as to the existence of any fact of a public nature, any statement of it made in a recital contained in any act of parliament of the kingdom or any act in any central act, provincial act or a state act, or in a government notification or notification by the crown representative appearing in the official gazette or in any printed paper purporting to be the London Gazette or the government gazette of any dominion, colony or possession of His Majesty is a relevant fact. So anything contained in any act, central act or state act, or published in any gazette, these will be relevant under section 37 of Evidence Act. I am coming to section 38 of the Indian Evidence Act. Relevancy of statements as to any law contained in law books. When the court has to form an opinion as to a law of the country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of such country, and to contain any such law and any report of a ruling of the courts of such country contained in a book purporting to be a report of such rulings is relevant. So when the court is to form an opinion as to the law of any country, say any cyber law of USA, any document published by the government of USA stating the law will become relevant in this regard, and that will be covered under section 38. Any judgment passed by the US court mentioning the particular law will be relevant so as to consider the law published, law enacted in the USA, and that will be covered under section 38. Now I am coming to section 39. What evidence to be given when statement forms part of a conversation, document, electronic record, book or series of letters or papers? When any statement of which evidence is given forms part of a longer statement, when any statement of which evidence is given, there is a long statement, I am taking a part of it and it is given as evidence. When any statement of which evidence is given forms part of a longer statement or of conversation or part of an isolated document, or is contained in a document which forms part of a book, or is contained in part of electronic record or of a connected series of letters or papers. So basically in section 39, whatever we want to say, any statement which is part of a longer conversation or longer statement or longer record or paper published in any book, evidence shall be given of so much and no more of the statement, conversation, document, electronic record, book or series of letters or papers as the court considers necessary in that particular case to the full understanding of the nature, effect of the statement and of the circumstances under which it was made. So let me explain it in a different way. In a book that contains 100 pages, and that particular book is divided into 10 chapters, and I am talking about a particular paragraph mentioned in chapter 5 of that particular book. So I am taking a small piece of a large book which contains different multiple chapters. Each chapters are divided into multiple paragraphs, and I am taking only one paragraph from chapter 5. So what is to be given? What part of that will become relevant? That is the question. What part? Evidence shall be given so much and no more of the statement, conversation, document, electronic record, book or series of letters or papers as the court considers necessary in that particular case. To understand that paragraph, whatever are required, that should be given in evidence, not the entire. In a book which is divided into 10 chapters, there may be that 10 chapters are divided are on different topics, but I want to give into evidence only a particular paragraph on a particular topic. To understand that paragraph, what other paragraphs or chapters are required, that will be given in evidence, not the entire. I think I could explain this section 39. I am coming to section 40. Previous judgments relevant to bar a second suit or trial. The existence of any judgment, order or decree which by law prevents any court from taking cognizance of a suit or holding a trial is a relevant fact when the question is whether such court ought to take cognizance of such suit or to hold such trial. When there was a previous suit or previous trial, and that previous suit or previous trial or the judgment thereof creates a bar for the court for any subsequent trial or suit or in any subsequent event from taking cognizance on the self-same cause of action, then the existence of the judgment, order or decree which by law prevents any court from taking cognizance of such suit or holding a trial is irrelevant. The judgment, decree or order will become relevant, which bars the court to take cognizance of any subsequent suit or any subsequent proceeding. Only the judgment, decree or order, not the entire suit, not the entire case record of the previous case. Only the judgment, decree or order. Today I am concluding today's discussion till section 40. From the next episode, I will start from section 41. Till then, I will request you to please subscribe and share this channel if you like the mode of my discussion. If you think that my discussion is helpful for you to understand the evidence. And till then, goodbye, stay blessed.